All right, good morning, Mr. Hunter. We're bringing you back because you now have a new fugitive case and you have a new lawyer. Um, what would you like?
Yeah, we're seeking fugitive bonds on these matters. The new matter, to the best of my knowledge, this from North Carolina, is basically the same complainants of the Houston case. Same folks. I think their surname is Beaker. I think a $30,000 bond has been set in the case here in Harris County. We would respectfully request bonds in the amount of 20,000 on the 3 fugitive warrants, and let my client sort things out with those other jurisdictions as well as ours.
Your Honor, because of the fact that he has now 3 fugitive cases in our court, 2 out of Knox County, Tennessee, and now a new one out of North Carolina County, we'll be asking for no bond.
I told him beforehand, we visited this issue before, and I told him the last time that he was here that I wasn't going to give him one. He just got way too much baggage. And it's all the same thing where it's a theft from an elderly, and we have the same thing that's occurring over and over and over. You know, and it scares me that if we let him out, is he going to pick up a 5th case, you know? Or it just, it's so much baggage. He scares me, you know?
All right. He does have, he's kind of been a resident of this area, you know, for 25 years. So
I get it, but he's got a lot. He's hopscotching with the states as far as criminality, right? He's got 2 cases in North Carolina, or 2 in Tennessee, 1 in North Carolina. Now he has 1 here. He's got, in 3 different states, he's got charges. It's too much. And I think that because of that, he's a big flight risk, and I don't want to lose him. You know, and he knows this because I've told him this before. You're not the first person that has approached on me with this. You know? So yeah, it's just, you got to understand that there's a lot that comes with this, right? If it was 1, perhaps, right? But you've got 3 in 3 different states. It's way too much. You know, at some point, it's got to stop. Now's that time. So the idea is that has he made bond? He hasn't made bond on the cases upstairs, right? So because you have not made bond, the 14 days here that would normally kick in is told if and until that hold upstairs is released. So if you're able to make bond on that theft case upstairs, that would kick in the 14 days for those states to come get you. And then they would have to battle it out as to who comes and whatnot, and, you know. So I guess just let me know what you guys want to do. The felony court is set for March 11th. Typically what we do is we just set it the day after. And I'm sorry, Mr. You know, but it's just too much. Yeah.
Your Honor, I do also want to add, he hasn't waived on this new North Carolina case, so he wants to start that clock today.
Okay, I'll let you guys see if that's something that you want to do. You know, if not, we can go ahead and get a governor's warrant. That'll take 90 days. But, you know, if you post bond on the case upstairs, that would get the ball rolling really, really quick. So, okay. You guys let me know what you'd like to do. Thanks. Mr. Riley, I've never met you before. I don't know you. I got to get to know you in the short time that we have here to see who are you? Are you a danger to our community? Well, everybody tells me that, right? Hold on. I know that you have a statement that you want to say, but what really matters is the paper, because that really tells me who you are. I get people that try to sell me the sun, moon, stars, everything here, but that really tells me who you are. So, Dave, let's get to know Mr. Riley.
Your Honor, he's wanted out of Louisiana for a domestic battery involving child endangerment and theft, but the theft is a misdemeanor, so he's only being extradited on the domestic. It was where he is alleged to have bitten his live-in girlfriend in front of a shared child and a second child, a 4-year-old and a 7-year-old. The warrant was issued on May of last year, so we're getting close to a year, Judge, for the
So he's been on the lam, you're saying, for a year?
Well, I don't believe it's an FTA, I believe it's a 2B1.
What's it to be? Okay.
I don't show any other history, and so state just requests that a sufficient bail be set, but I don't know of his ability to.
So you're okay with the bond?
I'm okay with a bond. I'm not okay with a low bond.
Judge, my client has requested that he address the court.
Yeah, I know.
So let's not talk about the case because you have the right to remain silent. Anything you say can and will be used against you. You got to understand that I have a ton of prosecutors here. Whatever you say, they're going to sit there, type it down. It's very possible it may get back to the prosecutors in Louisiana somehow. So don't talk about the case.
Myself.
My only concern is, if I set you a bond, number one, are you going to be a danger to our community? Number two, are you going to go back to Louisiana? Those are the main and primary concerns.
That's what I want to assure you of. Okay, right now I'm working. If I stay here 14 days, I may lose my job. I pay on child support and everything. I talked to the bondsman in New Orleans already. You know what I'm saying? So as soon as I go up there, he gonna walk me out. You know what I'm saying? I'm gonna take care of the bonding and everything. But I just want to let you.
It's set there.
I'm checking that right now, Judge. I don't.
I,
No, there's no bond set, which means they'll set one as he self-surrenders, but I don't know what they would set it at.
So typically the way it works is if we set you a bond, we give you 14 days from the date of your release to go turn yourself into Louisiana. If you fail to go do that, you have to understand that there are serious consequences. I will revoke the bond, set it at 0, and I'm not going to give you another one. I don't care if you're kicking and screaming and Jesus told you to do something. I don't care. We give you one shot to go turn yourself into Louisiana. You understand?
Yes, sir.
Okay, so let's talk about a bond amount.
Your Honor, due to the offense and the fact that 2 minor children were present and the age of the warrant, is that state requests a bond of $7,500.
Judge, we'd request a bond set of 1,000.
Big difference.
It's a pretty big deposit, Judge.
So the problem is that because you're a fugitive, right? You're an inherent flight risk. So the normal 10% that one would have to pay to typically bond out usually does not apply in fugitive cases, as far as I've been told. So you will probably have to pony up 100% of the money to be able to bond out on a fugitive case. So I guess speak with him, let me know, what's something that you guys.
He told me he could make $1,000 bond.
Yeah, I think 1,000 is too low.
That's the amount that he can make.
That's too low. I mean, that's what we do on normal cases, not just,
Unless I get new information, Your Honor, just again, due to the age of the warrant and the fact that there were minors present, unless I get new
I
information.
don't want to keep you, right? But I have to make the bond sufficiently high so that I know that you're going to go back, right? What I'll do is I'll set your bond at $2,500, okay? And then just let me know, what we can do is, has he already waived or no?
No, he has not.
Have Abel reach out to your folks, your family, to see whether you guys can make it.
under 2,500.
This is not I'm not going to negotiate with you, dude. This is just that 1,000 on a fugitive case with this type is just too low.
And also, just binding counsel in the court is that even presuming that he's able to make this because Louisiana has set at no bond for him to return and go back to work, he has to make a secondary bond there. And if this is the maximum he is able to pay, then effectively he'll be held in Louisiana and he won't be able to return.
I'll have to take that into consideration.
Judge, my client has chosen to not take the bond until if that's okay with court.
2,500, like,
Don't argue with it.
no. I just want
Here, look, let's do this.
to lose my job and everything.
Let's do this. Let's do this. I'll let you guys go back there, talk about what you can make. 1,000 is just too low, but I'm willing to work with you because, really. But you guys, no, let's not do it here. Go back there, talk,
I'll stand down, Judge.
Christine?
Mr. Riley, so you got to understand that actions have consequences, right? I'm setting your bond at $1,500. This is allowing you to be able to go turn yourself into Louisiana, right? I'm not going to play this game with you again. You're old enough to know that actions have consequences. We give you 2 weeks from the date of your release to go turn yourself into Louisiana. If you fail to do that, I'm going to revoke the bond. I'll set it at 0, and I will not do this again with you. I'm going to arrest you again because you can't run forever. And this time I'm going to hold you at 0 bond until Louisiana comes to get you. Do you understand? All right. So bond set at $1,500. All right. Best of luck to you, sir.
Thank you.
Okay. This was Miss.
Wilson, Paris Wilson.
Good morning, Miss Wilson. You're on a deferred, the type of probation for an extremely serious case. I mean, it's about as serious as it comes. You're supposed to live with a halo over your head, you know? Don't say anything. I'm just telling you, you gotta live like you got a halo over your head. You've picked up a new case with us. Lori is asking me to give you a PR bond, and I think everybody deserves a chance. So I will give you a PR bond now, but I'm not going to play this game. If you continue to pick up new cases, if you're a danger to my community, I'm not going to keep doing this. Do you understand? Okay. The problem is that you've not made bond upstairs. So I don't know if you're going to be able to, whether they're going to give you a PR bond or one. I don't know. So I will give you one with us on our failure to ID case here, but be good. It's not hard. Be good. No. Tell Lori, just what you got to worry about is upstairs, not us. Just be good. It's not hard. Do you know when the felony case is?
They haven't put a court date on there.
Actually, they have. 2/12.
Oh, okay,
Next
so
Wednesday.
Wednesday, and I'll reset you until the Tuesday after that.
You want to do the next day, perhaps?
Okay, we can do Thursday. All right. Trajan Edwin J.
Okay.
Trajan, I'm sorry.
Good morning, Mr. Edwards.
Edwin.
Oh, Edwin. I'm sorry. My fault. All right. So, Mr. Edwin, you're charged with evading arrest or detention. And criminal trespass. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 21 days in jail on the evading credit for 7. Is this what you want to do, sir?
Say that I'm getting out tonight.
Yeah, it's time, sir.
So time serves is very sexual to me. Thank you so much for it.
But you need to understand, this is going to go on your record. If you run from the police again, they can charge you with a felony offense. Do you understand?
If our Salveria toll licenses did not want me to get in trouble like this again.
I didn't hear.
Salveria toll licenses does not want me to be acquitted in being in a judge's face like this again.
He's saying somebody doesn't want him to get in trouble again like this.
You know what we're doing today, right?
Today is the lawyer's offense of licensing me to get out of jail, yes, sir.
Well, you're pleading guilty. Is that how you understand it?
I'm not necessarily pleading not guilty, yes, sir.
Are you guilty?
I am fully registered to be guilty.
What happens if you pick up another evading arrest?
We are resourceful and knowing to not do it. So we don't
What do you
want
say?
He said we are resourceful to knowing to not do it.
Hey, don't. You can get a felony next time. Do you understand? All right. You're giving up a lot of rights by doing this today. You don't want a trial. You don't want to talk to witnesses. You need to understand that there are consequences. It will go on your record. It will be there forever.
Just be like Salveria Toll Licensures. Just be like I am the CEO of Salveria Toll Licensures, which means I am a lawyer. You understand that.
Let me reset it, Judge.
We do not want to get in trouble.
Let's go back.
You're saying we do not want to get in trouble.
I want to make sure you understand, Mr. Edwin. Mr. Edwin, we just need to make sure you understand what's going on. Okay? You know that you're pleading guilty to this offense.
Yes, sir.
Yes, sir.
Do you know what that means?
Taking convictions.
Right. So you know that this charge will go on your record, correct? If you run from the cops again, you'll be facing a felony charge. You understand that? Okay. You also need to understand that by pleading guilty, you are giving up many rights. You don't want to go to trial. You don't want to talk to witnesses. You don't want to confront, cross-examine the people who are accusing you of this offense. You give up the right to appeal. Once you plead guilty, you can never change this. Do you understand? One more thing is that if you're not a citizen, they can deport you, exclude you from the country, or deny naturalization. Once you plead guilty, you can never change it. Do you understand? Okay, how do you plead to the offense of evading arrest or detention? I will find you guilty. I'm going to follow the agreement. Be careful. Don't run from police again. Okay? All right.
Good luck to you, Mr. Edwards.
Look, Mr. Edwin.
You're getting out today. All right.
Hi.
Naval this morning.
Okay.
I was just appointed to the case. He has a pending assault family member in this court. I believe that you had asked that he be drug tested this morning, if that's correct.
sent him for a drug
Oh,
Come up, Mr. Venable. Or Miss Venable. Mr. Venable. So we have him on an assault that's extremely old, and then he picks up an evading arrest in a motor vehicle. And the initial bond violation we have was
Failure to report.
it was a no-show at the scene. If you ever fail to show again, I will put you in jail. I will revoke your bond. Do you understand? Court orders are there for a reason, and when you no-show, that's not a good thing. We sent him for a test today, which is what we normally do, and okay, no more. You're not to use alcohol, illegal drugs, and I will test you 45 days from today. You test positive again for dope or alcohol, you will stay with me. Do you understand? I'm telling you now, you're going to get another test. So let's set it for 45 to 50 days. You must be here at the next setting and you will get tested again. You understand?
I have a question, my last.
We can provide you a lawyer. Your lawyer can answer the questions for you, but there's absolutely no tolerance. You have an open assault, now you have an open felony, absolutely no tolerance. You're a danger to my community. I only have one place for you.
I understand.
Okay, so we've given you a lawyer. It is your responsibility to stay in touch with her. If she tells you she can't get a hold of you because you're ducking and dodging and playing games, I will issue a warrant for your arrest. You pick up a third case, I will go nuts on the bond. Do you want to add anything?
No, Judge. For the court's awareness, he did have an open ABI that was dismissed because the complaint was since passed, related circumstances. It was an ABI, an old ABI that was still pending, then an evading.
Right. Right. And there's no tolerance. And so any more issues, I'll keep him with me. Okay. All right. Take a seat for me, sir. Thank you.
Judge, there's some conditions on the